Subscribe to our channel and press the bell icon to never miss an update from Rouse IAS. Do not forget to subscribe to our Telegram channel for all the updates and materials.
Hello and welcome to the explained section of Indian Express series of Rouse IAS, a series of video lectures where we discuss all those news items which have not been covered in TNS videos. In this particular video, we are going to take up important articles which have appeared in the last week, which was the last week of July. So let us now begin the discussion. And so we will begin the discussion with a very important article which appeared in this week's Explained. The Juvenile Justice, Care and Protection of Children Amendment Bill 2021. And this got the limelight because Union Cabinet has approved a lot of major amendments to the Juvenile Justice, Care and Protection Act 2015 in a bid to bring in clarity and also to entrust more responsibility on bureaucrats when it comes to implementing the provision of the laws. And so what you have in front of you is nothing but a line from the syllabus of your UPSC Civil Services Mains Examination, which says issues and challenges pertaining to vulnerable sections of society. And children right there are one of the most vulnerable sections of the society. And there are a lot of troubles they face. And so the government has enacted an act just so that our children can be well protected. They get the right kind of environment and nobody troubles them. And so we are going to first understand that act, the recent amendments, as well as the troubles or the challenges with the current set of amendments which have been proposed. And so let's begin by first understanding what or who is a juvenile. And so in India, a juvenile is a person less than 18 years of age. The Juvenile Justice, Care and Protection of Children Act 2015 addresses children in conflict with law and children in need of care and protection. And so you can see that it serves twofold purposes. You have to deal with children who have gone off track. You have to deal with them, but not the same way you would deal with off track adults, simply because the minds of the two people are different. So if there is a kid who is doing or is a part of some criminal network, you've got to deal with them in a different manner. And so this act provides for this as well, which are known as children in conflict with law. At the same time, there are a lot of children who need care and protection. For example, children against whom some criminal acts have been committed. And so you cannot take the risk of putting them under the same legal process as you would for an adult. And that purpose is also served by the same Act 2015. So just to make it clear, it addresses children in conflict of law and children in need of care and protection. And why did India do it? Of course, India needed to protect its children, but the commitment was made long back. The commitment was made at United Nations Convention on the Right of Child, the Hague Convention on Protection of Children and Cooperation in Respect of Inter-Country Adoption 1993. So you can see not just commitment to our own children, but also this act is a manifestation of commitment towards an international treaty, and in fact two of them. And so as a signatory, India was indeed required to undertake all appropriate measures to ensure that the right of children with regard to juvenile justice, care and protection and adoption is ensured. And so now let us take a look at the provisions of the act. Now here I would like to say that before this act of 2015, there was another act which this 2015 act replaced. So originally Parliament had passed Juvenile Justice, Care and Protection of Children Act 2000, which had a lot of issues which were resolved in this 2015 act. And so the first changes which were made was change in nomenclature. Earlier, the children below the age of 18 were addressed as juvenile, which this particular act changed to either child or child in conflict with law, because juvenile word is often associated with negative stereotype or it has a negative connotation. The meaning is not very positive in our society, and so that's why it was thought in the best interest of the children to replace it with child, the child who needs care, or the child who is in trouble because he or she is in conflict with some kind of a law. Then the 2015 Act was quite intensive. Then the 2015 Act is quite wide. It has several new definitions. For example, orphaned, abandoned and surrendered children, petty, serious and heinous offenses committed by children. So it has made a lot of distinctions as far as the definition of various kinds of children are concerned, which makes the law far more superior than its predecessor. Then we know that there is something known as Juvenile Justice Board and Child Welfare Committees. But in the earlier law, their powers, functions and responsibilities were not clearly laid out, which 2015 Act indeed did. The clear-cut timelines for inquiry has been provided. At the same time, the Act mandates setting up of juvenile justice boards and child welfare committees in every district, and it also mandates the representation of at least one woman in all of them. Then the 2015 Act now has a special provision for heinous offences committed by children above the age of 16 years. So earlier, the Act did not have any kind of distinction. If you are below 18 years of age, everyone was treated equally. And so what it did is that it allowed the trial of juveniles or children in conflict with law in the age group of 16 to 18 as an adults in certain cases of heinous crimes. And this provision was specially created in the wake of 2012 Delhi gang rape, in which one of the accused was just short of 18 years and was therefore tried as a juvenile, and he escaped punishment. And so there was a lot of public outrage as to how a hardened criminal like that would escape by utilizing the flaw in our law. Then adoption of children, especially the orphan children from orphanages and the children who were surrendered, was a big problem prior to 2015 Act. And to streamline adoption procedure for orphans, the first thing this Act did was that it made this particular agency, Central Adoption Resource Authority or CARA, a statutory stature so that it can perform its functions more effectively. It also added a separate chapter on adoption, which provided for detailed provisions relating to adoptions and punishments for not complying with the laid down procedure. It also provided for processes with clear-cut timelines for both in-country and inter-country adoptions, which was not there in the earlier Act of 2000. Because you should know that a lot of people do adoptions across the borders. And so there was a need for a legislative framework to provide for both of them clearly with the procedures. And so apart from this, an important feature of the existing Act was inclusion of new offences committed against children. Several new offences committed against children which were not adequately covered under any other law were included in this Act, which includes sale and procurement of children for any purpose, including illegal adoption, corporal punishment in child care institutions, use of child by militant groups, offences against disabled children, and kidnapping and abduction of children. Of course, these are criminal acts which find their place in IPC. So everything is well and good. Now, this week, the Union Cabinet has brought in amendments to this particular 2015 Act, which the government says is about giving more clarity and entrust more responsibilities on bureaucrats when it comes to implementing the provisions of the bill. If you look at the statement of objects and reasons of this particular bill, so every bill just does not start from the amendments. The propounder of the bill, which in this case is government, has to give some reason as to why they are bringing in this new law. And so the statement of object and reason states that the adoption cases have witnessed significant delays in court. Also, it says that adoption cases are non-adversarial in nature and can be dealt through a well laid out process. So basically this means that government wants to remove judiciary from the process of adoption. According to the government, judiciary is the one responsible for delays in adoption, and so that is why they are going to give this responsibility to the executive. And so now what we are going to do is that understand the amendments and the problem with the amendments. Alright, so the new amendments, right? This is why we are discussing this article. And so the new amendment brings about changes in adoption, in definition of serious offences, in providing for designated courts to try out children and acts against children, offences against children, and child welfare committees and their membership. So what are the changes as far as adoption is concerned? So currently under the Act, one prospective adopted parents accepts a child, an adoption agency files an application in civil court to obtain the adoption order. This order is issued by court which establishes that child belongs to the adoptive parents. Now the bill provides that instead of the court
The district magistrate, including additional district magistrate, will perform these duties and issue all such orders. So this is what is the main issue about the bill. It transfers a power of adoption from judiciary to executive. Then, currently the Act provides that the Juvenile Justice Board will inquire about a child who is accused of a serious offence. Serious offences are those for which the punishment is imprisonment between 3 to 7 years. Now the bill adds that serious offences will also include the offences for which maximum punishment is imprisonment of more than 7 years and minimum punishment is not prescribed or is less than 7 years. Then as far as the current regime is concerned, it provides for offences against children that are punishable with imprisonment of more than 7 years will be tried in children's court, which is equivalent to sessions court. Whereas currently other offences which are punishable with imprisonment of less than 7 years will be tried by judicial magistrate. Now the bill does away with such a distinction. If you do a crime against children, it doesn't matter what that crime is, you will be tried in children's court. Then as far as offences against the children is concerned, the bill provides that such offences will be non-cognizable and non-bailable. Now let us know in the comment section what do we understand by these two key terms, non-bailable and non-cognizable. Then currently the Act provides that states must constitute one or more child welfare committees for each district. Now currently the Act provides that states must constitute one or more child welfare committees for each district for dealing with children in need of care and protection. It provides certain criteria for the appointment of members to CWC. Now the bill adds certain criteria for a person to be ineligible to be a member of CWC. So if a person has any record of violation of human rights or child rights, or if he or she being a part of the management of a child care institution in a district, or if he or she is a part of management of a child care institution in that district will become ineligible, he or she will become ineligible to be a member of child welfare committee. And so these are the amendments which have been brought about. Now what is the trouble? And the first problem is that the statement of objects and reasons of the bill states that there is a significant delay in finalizing adoption cases in courts. And in order to expedite adoption proceedings, the bill empowers the district magistrate to issue such orders. So this is the justification which has been given by the government to transfer the power of adoption from judiciary to executive. Now if you look at the data between April 2015 and March 2020, about 19,000 children have been adopted, on an average 320 adoptions per month in the country. Now the question is whether this constitutes a significant delay and consequently requires shifting the power to issue adoption orders from the court to district magistrate because there were 620 adoption cases pending in various courts. Now, who is the one to judge whether this amount of pendency is something which needs amendment? The question is whether this constitutes a significant delay and consequently requires shifting the power to issue adoption orders from the court to district magistrate. Empowering district magistrate to issue adoption orders may also lead to delay as they already are burdened with several responsibilities such as maintenance of law and order, land and revenue administration, disaster management, general administration, and implementing government schemes and policies in their district. To give you an idea, a district magistrate chairs about 75 committees spread across 23 departments. And so where is she going to find the time to deal into adoption cases? Then of course the question is whether it is appropriate for an administrative authority to issue adoption orders instead of a judicial body. Because let's agree that adoption of a child is a legal process which creates a permanent legal relationship between the child and the new parents. When deciding on adoption, courts review documents, ensure necessary procedures or whether they have been complied with or not, conduct an inquiry of the child as well as the parents. This helps ensure that due consideration is given to the wishes of the child and the adoption is for the welfare of the child. It may be argued that determining whether the adoption is in the best interest of the child requires judicial training and competence or not, but you cannot deny the fact that it is actually quite a legal matter. And so these are the two main challenges which still face the new amendment. The next important explained article which has appeared this week is about pre-pack insolvency. How resolution pre-packs for MSME can speed up insolvency cases. And so the Insolvency and Bankruptcy Code Bill 2021 passed by Lok Sabha last week has proposed pre-PACs as an insolvency resolution mechanism for MSME or micro, small and medium enterprises. And so this bill will replace the Insolvency and Bankruptcy Code Amendment Ordinance 2021. And so in this regard, we are going to understand what are pre-PACs and how are pre-PACs better than CIRP or Corporate Insolvency Resolution Process. And so first, let us now begin to understand what Corporate Insolvency Resolution Process looks like, or how CIRP works. Company defaults on repayment, that's the start of the story. Insolvency process gets triggered, management of the company passes on to creditors, resolution takes place, and new investors may take over the company. This is how it goes. Now, all is good, but there are certain problems with this kind of resolution and insolvency procedure. Because first and foremost, promoters lose the control over the company. At the same time, due to the poor economic condition, not just in India but across the world, large number of companies have defaulted because of that. And it's unfair to take away the control directly from the promoters for something which is global, for which they are not responsible. Then there have been delays in the resolution due to unnecessary litigations. Then lower recovery rates for the creditors is a big problem. At the same time, there is a lack of trust between the creditors and the debtors, which makes the whole procedure of CIRP very, very complicated and time-taking. And so it is specifically because of this reason the government has come up with pre-PACs. So how does this pre-PAC work? A stressed MSME can prepare a plan for the settlement to secured creditors. Then a resolution plan is prepared and submitted to National Company Law Tribunal for approval. Then an agreement is signed between existing creditor and new investors, and because of which existing owners get to retain the management, which is the whole point of it. So the end product of pre-PAC insolvency is very, very different from the end product of CIRP. And so debtor in possession ensures minimal disruption to the business and jobs, because these are the people who initially started the business, they know it, and so it's best that they run it. It also at the same time reduces the time spent in litigations, decreases the burden on adjudicating authorities because of less complications. It will lead to higher value maximization due to Swiss challenge method, and international experience suggests that this has been actually very, very helpful and successful in UK and US. But at the same time, the important challenges are two. Only 120 days have been provided to complete the resolution process, which seems challenging. And then, debtor in possession model may militate against the Swiss challenge method, as the existing management may create hurdles for an outside investor who is seeking information to potentially invest in the company. This is a big conflict of interest. So these are the two challenges in the pre-PAC insolvency, but then you have a lot of advantages. And so to resolve any kind of confusion between the normal CIRP and pre-PAC insolvency process, we have prepared a table for you to clearly distinguish them. And these distinction on 7 to 8 very extensive parameters. As far as who can initiate this process, CIRP, either the creditor or the debtor. But pre-PAC insolvency process can be initiated only by the debtor. And the debtor must obtain approval of at least 66% of its financial creditor in terms of value. Pre-PAC insolvency process is a special mechanism which has been created only for MSMEs. CIRP process is applicable to all companies including MSMEs. We know that after the successful conduct of CIRP, the control of the company passes to the resolution professionals. But in case of pre-PACs, we have just learned promoters retain the control of the company. In case of CIRP, resolution process means restructuring of loans through public bidding, whereas in the case of pre-PAC insolvency process, restructuring of loans is done through direct agreement between promoter and creditors. Under CIRP, promoters are barred from bidding and hence lose the control of the company, whereas in pre-PAC insolvency process, promoters retain the control of the company. Under CIRP, external parties can bid for the company as part of the initial resolution process, whereas in pre-PAC insolvency process, no role in initial resolution process is given to external parties, and resolution takes place through direct mediation between promoters and creditors. And the new resolution plan is open for Swiss challenge method. So you can say this is creditor in possession, whereas this one is debtor in possession. So these are the two key differences between CIRP and pre-pack insolvency process.
Alright, so the next important news deals with the section of art and culture, Jaipur's Amagarh Fort, history and factors leading to the current conflict. So a fort in Jaipur, known as Amagarh, is in the center of conflict between the tribal Meena community and right-wing Hindu groups. Both sides have filed police cases and are running social media campaigns to assemble at the fort and to show their strength off. Now, this fort is not on UNESCO World Heritage Site list, or otherwise it's not a very important site of national architecture. But since it has come into news so much in last 2 weeks, it is important for us to cover it, at least just the location part. So it lies in Jaipur. And members of the Meena community say that Amagarh Fort was built by Meena ruler predating Rajput ruler in Jaipur and has been their holy site for centuries. According to them, people from the community used to worship Amba Mata and hence the name Amagarh Fort. According to historians, the present form of Amagarh Fort was given in 18th century by Maharaja Savai Jai Singh II, who was also the founder of Jaipur. It has always been believed that there was some construction at the place before Jai Singh II built the fort. And prior to Rajput rule by Kachwaha dynasty, Jaipur and its nearby regions were ruled actually by Meenas, so there could be some truth to the claims by Meenas about this particular fort. So from the perspective of prelims examination, Amagarh Fort lies in Jaipur, and as far as it stands now, it was established by Maharaja Savai Jai Singh, who happened to be the founder of Jaipur as well.